Mr. Lanto would like to, he's not going with any House counsel. He is wishing to represent himself. So today's the date and time set for the arraignment and pretrial. He is in prosecutor room 1.
Okay.
I'll be there.
He's going pro SE, and sure, that's his constitutional right. But let's be clear, it's a razor's edge with no safety net. From this moment forward, every word out of his mouth becomes evidence, and every slip-up in procedure is a trap waiting to snap shut. Judges, prosecutors, and even the rules themselves won't cut him any slack. It's not just representing yourself, it's walking into a courtroom minefield barefoot.
Let's get back to what I was doing. Case 230877 OM, People versus Lanto. Mr. Greco, you already placed your appearance. Sir, your name for the record, please.
Joshua Lanto.
All right. So today's the date and time set for an arraignment and pretrial in this matter. First off, as to the arraignment, sir, you do have the right to remain silent. Anything you say can and will be used against you at trial. You have the right to an attorney. If you cannot afford an attorney, one will be appointed to you by the court of public expense. Do you understand the
You just told me.
All right. Sir, are you choosing, I do have a court-appointed attorney here. Are you choosing to represent yourself today?
I am choosing to speak for myself.
Well, let's just represent, speak.
I mean, in legally.
Tomato, tomato.
Yeah, no, you can't represent.
No, just at any point, if you do wish to have a court-appointed attorney, please let the court know so that I can effectuate that right in your wishes with regard to it.
I appreciate that.
Now, with regard to the alleged charges in this matter, it is alleged that with regard to the arraignment,
The judge warns him, twice, that when you choose to represent yourself, every word you say can and will be used against you. That's the trap of going pro SE. You're both the client and the lawyer, and the client can't stop talking while the lawyer in your head is silently screaming, "Please, just stop." It's the fastest way to turn your own mouth into the prosecution's best witness.
separate case, whatever happened with
We
that
have the
case,
same thing going on in this case. We have a similar situation in this case, whereas I don't know if the prosecutor understands the cause and the nature of the charges because he had to dismiss the last case.
Yeah.
Right?
Well,
So how
I'm about to then let me read the complaint to you.
Okay.
Let me make sure you get a copy of the complaint.
And I saw your YouTube channel on I saw your video on YouTube. where
First
you
off, it's
explained-
not my YouTube channel. It's
Well,
something that's forced upon me that I'm required to do because there's a court order signed by my chief judge. I prefer to do all my cases in person, but I'm required to broadcast them live because
Any government entity willing to use transparency to put the truth on the table is 100% I'm in favor for because
I don't have anything to hide. I don't do anything wrong. I don't have any.
You did explain factual evidence of jurisdiction, though, and you did explain it for about the better part of a half hour to a guy. Last time I was on Zoom, I was told I was crazy for talking like that.
You didn't understand me, so.
Right, but I was told I was talking crazy for asking for it.
No, not at all.
Okay, so I'm not crazy. Okay, that's first and foremost.
You can always challenge jurisdiction. Jurisdiction is something you can even challenge for the first time on appeal. One of the only things you can challenge for the first time on appeal.
Well, luckily we have about 160 people watching us right now that have heard that for the first time that probably don't understand.
People watch a couple of things on YouTube or a couple of things on Google, and they think they become illegal.
3 misdemeanor counts, each carrying up to 93 days. And let's be clear, the charge isn't about filming police, because recording officers is generally protected speech. The issue here is interference, the proximity, the timing, the obstruction. Free speech has limits, and it stops the moment it collides with someone else's legal duty to act.
Before you start discussing the facts of this case, I am going to caution you that you have the right
Fifth
to
Amendment,
sign
yeah.
it.
I don't sign anything, so I'm just.
That's a copy of the.
Okay, appreciate that. And now is there?
So now I'm going to read into the record what the allegations are. It is alleged that on November the 17th, 2022, that you violated City Ordinance, Chapter 32, Article 2, Section 32-31, interfering with police authority, which states shall be unlawful for any person within the city to resist any police officer, any member of the police department, or any person duly empowered with police authority while in the discharge or apparent discharge of their police authority duty, or in any way to interfere with or hinder the police officer or member of the police department in the discharge of the police authority duty.
And
It is
just a
alleged-
quick objection, just a point of clarification.
There's no objection to that because that's just that is the ordinance.
Okay,
Literally
if you're
read the
just reading
ordinance
it into the record, I
I
understand.
don't read the ordinance. That's
Yeah, I just want to know what in any way in this charge. What does
Again-
in any way?
Again, I can't answer that question because for me to answer that question would be me giving you legal advice. If you want to file a motion, you can more than welcome to file a
Yeah,
motion.
because in any way
And I can
seems
make a
awfully
rule.
vague and it seems obtuse and it seems like it's just
These are all
impossible to.
great things that somebody might want to argue in a motion.
Yeah, it seems impossible to determine what in any
So,
way.
but if you
This is absolute gold for viewers. Yes, judges have to stream under local rules, and yes, jurisdiction can be challenged, even on appeal. But let's get this straight. That doesn't mean YouTube law suddenly wins. It means there's a formal process to raise it, in the right place, at the right time. Google is not a law degree, and courtroom procedure isn't something you hack with a search bar.
down to the bottom here because I want to let you know exactly what the allegations are against you from a factual basis. These are the reasons that the warrant was signed, because I found that there was probable cause that a crime was committed and probable cause that you were the one who committed the crime, hence why the warrant was placed into existence in the first place. It is alleged that on the above listed date, which was 17 of 22, at approximately 2:50 p.m., you, the defendant, Mr. Lanto, engaged in a repeated course of conduct to interfere with Officer Andrew Borg's discharge of his authorized duties, which include traffic enforcement on South Telegraph Road near Ecorse Road in the city of Tampa. You, Mr. Lanto, allegedly had unlawful actions, including following Officer Borg on multiple traffic stops, approaching the traffic stops in close proximity to Officer Borg and his vehicle and the drivers, yelling obscenities and insults at Officer Borg, and video recording Officer Borg while inside of his patrol vehicle while he was accessing protected lien information concerning the drivers that were pulled over. It's also alleged, Mr. Lanto, you were ultimately arrested after witnessed you walking within close proximity to Officer Borg's vehicle during a traffic stop and attempting to video record Officer Borg while he was inside his patrol vehicle accessing lien information.
Here's the factual core: repeated approaches, closing distance during traffic stops, and filming while an officer's in-car system displays protected data. That last part is critical. Filming itself is legal, but filming sensitive database screens at arm's length during an active stop is exactly how you cross into interference. The line isn't the camera, it's the conduct.
More specifically, in count 1, the violation of section 32-31, interfering with the police authority. Lanto, the defendant, allegedly approached the traffic stop at approximately 3:04 p.m. and interfered with Officer Borg by being in close proximity to Officer Borg, his patrol vehicle, and the pulled over driver, median of Telegraph Road, and yelling and hurling insults and obscenities while Officer Borg was discharging his police authority duty. In count 2, violation of section 32-31, interfering with police authority. You, the defendant, Mr. Lanto, allegedly approached the traffic stop at approximately 3:12 p.m. and interfered with Officer Borg by being in close proximity to Officer Borg, his patrol vehicle, his patrol car, and the pulled over driver, the parking lot of the Tropical Smoothie Cafe, and yelling and hurling insults and obscenities while Officer Borg charging his police authority duty. In count 3, it is alleged a violation of section 32-31, interfering with a police officer, and that you, the defendant, Mr. Lanto, allegedly approached the traffic stop at approximately 3:31 p.m. and interfered with Officer Borg by being in close proximity to Officer Borg, his patrol car, and the pulled over driver in a parking lot on South Telegraph Road, and attempting to video record Officer Borg while he was inside of his patrol vehicle, accessing lien.
Classic arraignment standoff. The defendant refuses to enter a plea, so the court steps in and enters, not guilty, on his behalf. That's not punishment, it's procedure. The system won't stall just because he won't play along. It's the court's way of keeping the train on the tracks and the case moving forward.
Before I make an informed.
This isn't a matter of clarifications. This is you either pleading guilty, not guilty, or standing mute.
Well, I was told I had the right to be informed of the cause and the nature of the charge. You just read this into the record, and all it did was confuse.
I did.
So, because we have right in here, Officer Borg, or I was told
Listen,
everything
I'm
was
not-
close proximity of
Sure.
door.
I'm not
What
going to
is-
get
what
into
is
the
close
particulars.
proximity?
I'm not going to get into the particulars. This isn't the trial. This is, nobody's sworn in under oath. There's a subject to cross-examination by both sides. That's what trials are for.
Okay,
That's what trials are for.
before I make
This
an
is just these things. So I'm going to give you 5 seconds to either choose or just don't say anything. Or if you're not responsive, then I'll just enter a plea of not guilty so that your not guilty status is preserved and your constitutional rights preserved. So how do you plead? Guilty, not guilty?
I object for clarification.
The judge's scale analogy is evidence 101, reliability versus accuracy, and why trials are built to test both. If you're going pro se, this is the homework you can't skip: foundations, hearsay, relevance. Without those tools, whatever truth you think you're presenting never even makes it into evidence.
The warrant.
Yeah,
The warrant charging instrument. The warrant.
yeah,
The warrant charging instrument. The warrant.
yeah,
The warrant charging instrument. The warrant.
yeah.
The warrant. Set this up for, if you want a trial, we'll give you a trial. That's what
I
I'm
mean, if
saying.
you want to see what happened,
And again, all of that would be done at a trial. If you're going to bring in evidence, it has to have foundations. You have to lay a foundation for every piece of evidence.
Well, then-
Evidence doesn't just come in. It has to be factually accurate and it has to be reliable.
okay,
If they're
so,
not both, that's how you lay a foundation for evidence. I have a scale in my garage. Every time I get on it, it says I weigh 187 pounds. I love that scale. Mwah. It's very reliable. Every time, 187. Mwah. Guess what? The scale's not accurate. Reliable, but it's not accurate. All evidence has to, and that's what we do at trial. Today is just the day when I'm telling you, this is what you're facing. This is what they are alleging that you did. And if you'd like to set it for a trial, you can do so. If you'd like to have the assistance of an attorney, I'll make sure that you have an attorney present with you. Even if you just want them riding shotgun with you. So
Calling a judge a mob boss isn't bold, it's pure self-sabotage. Courtrooms run on professionalism, and the only currency that spends is facts and law. Disrespect doesn't just cost you style points, it shreds your credibility. And credibility matters at every single stage of a case.
he actually had a different case, and he was actually a lot more fair than I originally gave him credit for. So the mob boss judge, I'm glad he's not here. He's the one that told me I would be assigned an armed.
Well, first off, I don't find I find it disrespectful to refer to somebody as a mob boss. That's because that literally is,
That's how it felt to me.
well, what I'm saying is you're just liable.
That's how it felt.
Because now you put him in what's known as false light. And I'm just telling you, I wouldn't do that.
Well, I appreciate the
For
warning.
civil reasons alone, I wouldn't do
I
that.
appreciate the warning.
And I'm not going to allow any sort of disrespect to the judiciary, especially when I didn't watch over it, and especially because the Judicial Tenure Commission, if they sanctioned the action, then sure, I have no problem with making commentary about it.
I don't think
Until that's been, there's no need for doing that.
Yeah,
And trust me, you're not going to garner any favor, nor are you going to do anything but lose respect for me if you're just going to throw like petty comments in there like that.
Smart move, discovery, and a settlement conference. This is where real cases actually get resolved. Reports, videos, CAD logs, body cams, policy directives, all of it comes out here. If his claim is, I didn't interfere, discovery is how you test that. Not speeches, not theatrics.
So let the law speak for them, and they just keep it professional.
Okay, well, as long as we're just here to put facts on the table, I can do that.
Sure. Then you've been advised, and so you are either free to go or free to talk to Mr. Greco further.
All right, I mean, if he wants to talk to me, we can talk.
All right, Mr. I can always, you can sign back in, or Mr. Greco, are you available to talk any further today on this case?
Your Honor, Mr. Lanto and I have spoken, and it's either going to be set for a settlement conference, and we can provide him some of the discovery information with the order, or a trial. That's
so let's-
for us to talk about it anymore.
Getting the discovery regardless.
You haven't asked for discovery, but what I'm
I asked Mr. Greco in the,
Yeah, he's going to get it regardless. It's just what is set for. Sorry.
So what I'm going to do is I'm going to set this for a settlement conference, give him the date in the mail of when that settlement conference is. Mr. Greco, if there's any discoverables, type discovery, make sure you send that to Mr. Lanto. Mr. Lanto, did you provide Mr. Greco with an email and a phone number? Or
he's got my email. He's got my email. And then just to make sure the record accurately reflects what the request was from Mr. Greco, I did request number one, the factual evidence jurisdiction, and what he's using as a charging instrument to prove.
I gave you a copy of the check.
But it does nothing to explain jurisdiction. You went over it for a half hour.
I don't surrender jurisdiction? The court already has it if the statute applies and service is proper. Saying magic words doesn't make it vanish. If you want a real shot, put your energy into facts, not slogans.